All rise.
Okay, you may be seated. Good morning, Council.
Good morning.
Our final argument for today is Covel versus PNC Bank. This is case number 300. I say 30068. We're sitting here in Suffolk County. Judge Callahan and Judge Sutton and I are on the panel today. I'll be presiding, and I will be keeping track of time. So Attorney Buchanan, if you are going to reserve time, let me know and I'll let you know. Well, not only will I let you know, but we also have the clock up here. Each party will have 15 minutes to present the arguments. You may reserve up to 5 minutes. We do record the oral arguments and post them on our YouTube channel, so we ask that you stay at the podium and keep your voice up. No references to children or victims, which probably is not an issue in this case. All three of us have read the briefs and we are prepared to proceed if you are. How long would you like to reserve, sir?
Thank you, Your Honor. May it please the Court, Samar would like to reserve 5 minutes for rebuttal.
5 minutes. All right, thank you.
Thank you, Your Honor. May it please the Court, I am Attorney Wesley Buchanan. I have the privilege of representing Samar Covel, the appellant in this matter. We'd indicate for the record that this Court is permitted to do a de novo review of the record because this was a grant of a motion for summary judgment, which means that all the inferences and whatnot will bounce into Samar's favor. As far as the first issue that Samar would note for this Court, it is unclear whether or not the trial code took into consideration her verified complaint. If you'll note on the Court's decision on page 16 on footnote 4, the trial court specifically stated, quote, "This court notes plaintiffs have failed to produce any evidence that the HUD lien is not in the first lien holder position," end quote. Under Samar's verified complaint on paragraph 21, she indicates that her home loan remodification was removed from the first lien position specifically. I would draw this Court's attention to Jackson v. Alert Fire and Safety Equipment, Inc., 58, Ohio State 3D, 48, page 51.
Is that in your brief?
It is, Your Honor, and it was also in the motion for summary judgment. Also, State Ex Rel Spencer versus East Liverpool Planning Commission, 80, Ohio State 3D, 297, which also indicate that the trial court is permitted to take a verified complaint when considering a motion for summary judgment. Whether the motion for summary judgment decision references the complaint, it doesn't reference whether or not it was the verified complaint. So we can only listen to what the trial court does speak through its journal entries. We'd also indicate, as far as the facts here, Samar, like thousands of people here in Summit County, responded to a home loan refinance request and advertisement for PNC. She did have a HUD loan modification that she did execute and was part of the record that required the HUD loan to be in the first lien position. So she engages with Corey Williams, who was the mortgage broker in this case, and the loan officer representing the bank. They go through the process of underwriting. Samar provides that information, specifically the HUD loan, to PNC, and on June 13, 2016, which was Defendant's Exhibit M to Samar's deposition, there was a commitment letter made by the bank. And in that commitment letter, the bank asks for the home loan modification paperwork. In Corey's deposition on page 26 and 27, Corey indicates, which is through Plaintiff's Exhibit 14A and B, that she did provide that information to PNC. And then the underwriter cleared that condition, which Corey Williams, the mortgage broker in this case, testified to in his deposition. And then on August 13, 2016, this is in Samar's deposition and Defendant's Exhibit N, Samar signs an affidavit saying that she does not know any other liens. In that, she writes none. Well, the genuine issue of material fact would be, does none mean that she had already disclosed the lien, because by August 13, 2016, she had, or does none mean something else? And again, on a summary judgment motion, all we are looking for is a genuine issue of material fact. And in this case, that would present a genuine issue of material fact. And one of the questions is that the trial court applied was the statute of frauds and the parole evidence rule to summarily dismiss most of, if not all, of Samar's claims. Jason, her husband, is part of the claim, as the bank did not raise failure to join all necessary parties as a defense. However, because they are married and they were listed on the mortgage property, that is why he was included in the lawsuit. Because I don't believe at that time the state of Ohio had removed dowry rights. So that is why he had to be listed as a party for this case. So we indicate that, for the record, that is what needed to be there as far as Jason is concerned. Now, again, as far as they are concerned, Samar did provide this information to the bank, the PNC. They went through the underwriting process. The HUD loan, the home loan modification, was in writing. And there were some allegations of oral statements in addition to Samar Covel's verified complaint. She also testified through that she was told by the bank personnel to default on her loan, which goes to a genuine issue of material fact, because that might be a TILA violation. If a bank tells you, hey, you need to default on your loan, then we can help you. Now, whether or not that is barred by parole evidence, this definitely goes to intent of the parties, at least in regards to why they were entering into the contract. It is clear from Samar's deposition that she was entering into the home loan refinance with the bank and told them about the HUD loan. Part of her claims of fiduciary duty violations against Mr. Williams Corey was that he had at that time a duty to inform her that this would have affected her HUD loan, because at that time revised code 1322-081 was in effect, and that imposed a fiduciary duty. Now, there are some case law that says that a arm's length transaction between a financial institution and a consumer does not create a fiduciary duty. However, this was a statute, and that it was in effect at the time, and subsection 5 specifically says that make reasonable efforts to secure a residential mortgage loan from lenders with whom the registrant, licensee, or person regularly does business with, rates, charges, and repayment terms that are advantageous, and I emphasize, to the buyer, end quote. In this case, a term of the loan would have known that if Mr. Williams would have said, Samar, if you do this refinance with PNC, we're going to affect the HUD loan. And then if she was notified, she signs off on it, then I don't think she has a lot of complaint here. However, that did not occur because she was upfront with the bank. She provided all the information that she had, specifically in regards to this information, because as common experience tells us, when we purchase a home or refinance, there's an awful lot of paperwork that one has to sign. And she did that, and there was no intent on her part to definitely mislead or anything else like that as far as as far as Samar is concerned.
Counsel?
Yes.
As to that last comment you made, didn't the HUD loan paperwork actually send that fact out?
Yes, and that's why she provided it to the bank, because it's part of the underwriting process for PNC. They wanted to have that home loan modification information, and that was referenced when the underwriter asked for that information from Samar. Samar did provide that, and that was testified to through Samar's deposition and Corey's deposition, where they used a specific portal where borrowers could respond to the lender and provide information that the underwriter requested.
Was there any documentary evidence in the record regarding that provision of the HUD loan paperwork?
It would have been, as the HUD loan paperwork, it would have been in Plaintiff's Exhibit 14A and B. It would have been on Defendant's Exhibit N, Defendant's Exhibit O, and Defendant's Exhibit M. M, N, and O. And that would have been within the record. Defendant's exhibits were admitted through Samar's deposition, and then Samar's exhibits, plaintiff's exhibits, were admitted through Corey's deposition. So at least for the record, that would be how someone would answer that question. As far as her other claims and the purpose of the statute of frauds, it's not to fraud, it's to shield fraud. I mean, that would almost nullify the rule. In this case, we have a writing, which is the HUD loan, and we have a writing, which is the PNC loan. And again, it was under Samar's position that because she told the bank, PNC, for the second home loan refinance, that it wouldn't be affected, and obviously her rights wouldn't have been. However, when PNC refinanced her mortgage, that kicked HUD off the first lien position. HUD believes them not to be in the property anymore, and that triggers the HUD's acceleration clause and due and payable clause. And I want to make sure that I say that correctly. And so from HUD's perspective, through the Treasury Department, they start sending her letters and saying, hey, you owe this balance, with interest accruing daily. They begin to take her income tax refunds, any economic stimulus payments, and anything in that regard. And so that is obviously the harm that Samar has suffered. And at least she would indicate that the parole evidence rule can be set aside when it comes to the intent of the parties. And I think clearly that is the intent here. Are there two writings? Yes. The trial court specifically found in their motion for summary judgment that there was an express writing. And that's part of the reason that they granted summary judgment for P&C, who I am referring to as the bank. So I apologize for using slang term without defining myself here. When I say P&C, I mean the bank. And so I would indicate for the record that the intent was for Samar to notify P&C of the HUD loan modification. There was also intent there for her to indicate to them, I don't want you to affect this loan, because if you affect this home loan modification through the HUD department, I'm now going to have to be responsible for it. So in actuality, what Samar was asking the bank to do was refinance a second mortgage, and because the HUD home loan modification was supposed to be in the first lien position.
Just note during your rebuttal time.
Oh. And then if the panel does not have any other questions, I will reserve the balance for my rebuttal.
All right, 4 minutes, 51 seconds. Attorney Buchanan. Attorney Schiffer?
Yes.
Okay, very good. You have 15 minutes.
Thank you. Good morning, Judge Teodoso, Judge Callahan, Judge Sutton. Good morning. May it please the court. The trial court correctly granted summary judgment in this case for the following reasons. First, the trial court recognized that this case presents quintessential utilization of statute of frauds, in the sense that appellants were attempting to rely entirely upon alleged oral conversations to deviate, modify, or otherwise avoid the express written terms of the mortgage agreement. The trial court also set forth a multitude of additional reasons to grant each one of the 15 causes of action set forth in the complaint. Those additional reasons were not challenged in the appellant's brief, and only at most reference a little bit this morning during our oral argument. The independent reasons beyond the statute of frauds by themselves would support affirming the trial court's decision. But I'll start by talking about the statute of frauds because it is dispositive of the claims that the appellant brings in this matter. As described in the briefing and during appellant's oral argument, Ms. Covel had modified a mortgage with Fifth Third Bank prior to refinancing P&C. As part of that refinance, she received a partial claim from HUD, which resulted in loan documents generated by HUD, two different promissory notes and a mortgage, and a separate modification agreement with Fifth Third Bank. That modification agreement with Fifth Third does not say anything at all about the HUD loan within the four corners of that document. The HUD loan documents state very clearly that the $60-some thousand due and owing to HUD was due on the maturity date in 24. Those loan documents also explicitly state there will be several events which accelerate that loan payment, including, but not limited to, paying off the Fifth Third mortgage. When the Fifth Third mortgage was paid off as a result of the refinance, that triggered the acceleration of the HUD loan. Throughout the loan application process, as set forth in the record and in our brief, there were multiple written opportunities to disclose the HUD loan. The record is unequivocal that all of those documents do not set forth or describe the HUD loan in any way, shape, or form. Throughout the argument this morning, counsel has suggested that Ms. Covel provided the HUD loan documents to P&C Bank. Respectfully, that simply is not supported by the record. What the record shows is that Ms. Covel provided the Fifth Third modification agreement to P&C Bank. As discussed during her deposition and as set forth in the exhibits, P&C had requested a copy of the modification agreement, which was provided. However, the HUD loan documents were not provided to P&C at any point in time. And as a practical matter, had P&C been provided with those loan documents, it would have made no sense for P&C to proceed with the mortgage as it was drafted. It's to P&C's detriment to allow the mortgage to be created with HUD remaining in the first lien position. And I should also emphasize, and the record supports this, the HUD lien is the first and best lien on this property. As referenced by the documents that are set forth in the record, the HUD mortgage was recorded years before the PNC mortgage was recorded. There's no subordination agreement, there's nothing that would put PNC's lien in front of the HUD mortgage. So the HUD mortgage was, is, and remains the first and best lien on this property at all times. And with regard to the comment during argument this morning, which was not set forth in the brief, about the trial court not referencing the verified complaint, the trial court simply noted in a footnote that there was no evidence to support the assertion that the HUD lien was not the first and best lien, but she also made it clear in that footnote that for purposes of her summary judgment decision, she was viewing the facts in the light most favorable to the non-moving party as she went through each of the claims to make her decisions. So whether or not the HUD lien was first or second will ultimately not have impacted the trial court's decision in any way. At its core, this comes down to extremely well-settled Ohio law. Mortgages are an interest in real estate. As such, under the statute of frauds, which clearly states no action shall be brought for any of the categories covered by that statute, including interest in real estate, unless they are in writing and signed by the parties. The contention here is that allegedly PNC said the HUD loan would be forgiven and therefore she could proceed with the loan refinance. It's undisputed that that's not in writing. There's nothing in the record to indicate that there was any written communication that said that. And in addition to being precluded by the statute of frauds, that also would clearly run afoul of the full evidence rule, where there are multiple written documents, integrated agreements between the parties, whether it be Ms. Covel and HUD, or whether it be Ms. Covel and PNC. Nowhere within the four corners of either of those contracts does it say anything about the HUD loan being forgiven or otherwise avoided. Pursuant to the full evidence rule, as the trial court correctly recognized, appellants cannot rely upon alleged oral promises to deviate or modify the terms of written agreements that were executed between the parties. Appellants have contended in their appeal that the statute of frauds can be avoided by the full evidence rule. Respectfully, that argument fails for two reasons. First of all, it simply does not accurately reflect Ohio law. The cases that appellants have cited to involve situations where, in the absence of any written agreement, courts, including this court, have recognized that the parole evidence rule may be a defense to a claim in which someone is attempting to enforce an oral contract. May be a defense to such a claim. In no instance that I'm aware of from our research has any Ohio court ever allowed the parole evidence rule to be the basis to offensively overcome the statute of frauds and avoid the statute's clear language which says no action shall be brought. As opposed to the cases relied upon by appellants, this case is squarely on all fours with this court's decision in Reddish, Fifth Third Bank versus Reddish, cited in our brief, 2002 Ohio 5030. Like the Reddish case addressed by this court previously, that case involved a situation where a borrower entered into a mortgage with a lender. The borrower alleged that in the process of applying for that mortgage, that she was told by the lender that the interest rate would change if certain things happened after she entered into the mortgage agreement. Ultimately, that borrower defaulted, there was a foreclosure action brought, and she asserted this alleged oral representation that the interest rate would be changed among her defenses in that foreclosure case. This court recognized that her argument was squarely precluded by the statute of frauds, just as it is in this case. This is, again, a mortgage dealing with interest in real estate. And in order for plaintiff appellant's theory to have any viability, there would have to be a written document setting forth the promise that was made. The other issue with appellant's contention that the doctrine of promissory estoppel could avoid the statute of frauds is that there simply is no viable basis supported by the record for a viable promissory estoppel claim here in this case, for two reasons. Ohio law is well settled that promissory estoppel cannot exist as a viable theory of recovery when there is a written contract between the parties, as we have here. Promissory estoppel is a quasi-contractual claim that applies in equity in the absence of written agreements between the parties. Here, again, as clearly set forth by the record, the parties entered into a written agreement which memorializes the terms, and therefore promissory estoppel, as the trial court recognized, simply cannot exist as a viable theory of recovery. It also could not exist upon the merits of its claims because it requires a party to reasonably rely upon a clear and unambiguous promise. Here, respectfully, the record does not support those claims, as the trial court recognized, because the alleged oral promise is squarely inconsistent with not only the written terms of the HUD loan documents and the PNC mortgage, but also all of the submissions, including a title affidavit, which repeatedly said there was no mortgage, no interest, other than the Fifth Third mortgage that was going to be paid off. For all of those reasons, the trial court correctly recognized that under well-settled Ohio law, there simply was no viable basis for the claim that was asserted, and even viewing the facts in the light most favorable to the non-party, summary judgment is appropriate. The trial court's decision is thorough, it's well-reasoned, it cites extensively to Ohio law, and respectfully, appellants have not and cannot assert a viable basis for it to be reversed. Therefore, for the reasons set forth in our brief and for the argument today, we respectfully request the court affirm the trial court's decision. Thank you.
All right, thank you, counsel. Let me check with my colleagues before you leave.
Of course.
Questions, Judge Sutton, Judge Callahan? All right, very good, thank you.
Thank you so much, Your Honor.
Your time will be on the very top of 451.
Thank you, Your
For
Honor.
rebuttal. Go ahead, Attorney Buchanan.
Thank you, Your Honors. May it please the court. Again, Samar and Jason would indicate to this court that a genuine issue of material fact was submitted to the trial court, and that the trial court did err in their reasoning, and that because summary judgment is inappropriate for when a genuine issue of material fact exists, this court, and that's what Samar and Jason are asking, is to reverse the trial court's grant of summary judgment and to remand so that they may have the opportunity to proceed further. And if the panel does not have any other questions, we would thank you for your time and consideration.
I do have one quick question. Opposing counsel said the record does not support that your client gave the HUD loan documents to PNC. How would you respond to that? What is the record is there that would support?
As indicated previously, I believe in defendant, when Samar was deposed on defendant's M.
Yeah, that's M-O.
M-N-O.
14A-B.
Correct, and I believe when the court takes a look at those, one of the commitment letters on June 13, 2016, and I believe that's defendant's Exhibit M, indicates that the PNC is requesting the home loan modification information. And then the spreadsheet that was provided through Corey's deposition, which is plaintiff's Exhibit 14A and B, notes that that condition was cleared, and that using the trade usage in Corey's deposition means that she had provided that information. So that's how we would answer that question.
Okay, I just want to make sure my notes were correct. I had that down, but thanks for answering, or for covering that again for me.
Not a problem. And if there's nothing else from the panel, Samar, thanks again for your time and consideration.
Something, anything?
And Jason, I apologize. I don't want to do that. Thank you, Your Honor.
Thank you both for your arguments today. The court will take the matter under advisement and issue a decision in due course. The decision will be mailed to you on the day it is released, and you may check the Supreme Court of Ohio's website where our decisions are posted. We also want to thank the parties who showed up today. As I mentioned at the last argument, we don't get too many visitors, so it's always nice to see people in the back.